日子，因为最高法院今天开始听证，就是究竟在美国出生的子女是不是能够自动获取到美国公民身份。这个第14修正案的话，今天在最高法院进行听证。当然这个川普总统也是亲自参与的参加了在最高法院一般的话，它是这个一般不是每个案子都能够到最高法院里面听证的，每年有大概5000多个案件送到最高法院要求审理但是最高法院会挑出大概100到150个已经有意义重大的一个案件，而这个案件里边的话牵涉到就是究竟川普总统有没有这个权利签署总统行政命令废止所有在美国出生，如果他们父母不是美国公民或者是美国合法移民的话，他们的子女是不是能够获取到身份川普总统在上台的时候第一个事情就是颁布总统行政命令取消了他们这些这个身份。当然这个案件有20多个州起诉以后现在在最高法院里面进行听证。当然最高法院这个里边它一般的话只有不到100个旁听席让媒体让这个相关的律师团队来进行听证。不过在这里边的话这个川普总统他特意亲自到最高法院里边听证很多人解读就是川普曾经说在关税的时候他要去但是因为时间很忙没有过去。另外一方面川普这次亲自到，这也有可能是给这个保守派的法官施加一些压力。另外一方面川普在这个在昨天的记者会里边一再提到的话，他已经在他的推文Truth Social 里边也说，有些法官包括大法官他们这个没有这个胆量以后跟民主党背景的法官一样团结一致。他们有些法官的话这个并没有这个勇气所以川普的话亲自到最高法院里边去，有可能是一方面让外界解读可能是给最高法院，尤其是他3名任命的这个大法官有可能给他施压。在最高法院里边的话，我们可以看得出这个前面这个前排的这个法官里边的话，这个 Clarence Thomas 是黑人大法官，是保守派的这个 John Roberts 是属于主审大法官，然后他是这个共和党布希总统所任命的但是的话他可以看得出是有的时候不一定会这个按照这个保守派的理念来判。当然的话 Sammy Alito 是绝对的保守派，所以前面这2个里边的话都是属于这个坚强的保守派。当然的话前面这2个女的话Sotomayor 是拉丁裔首位拉丁裔的大法官，也是女性的。然后这个Elena Kagan 也是一个女权运动的领袖，所以话这2个的话都是属于自由派的。在后排里面我们可以看得出 Amy Barrett这位由川普任命的这个女法官以后还有这个Neil Gorsuch 也是川普所提名任命的，包括另外一名是 Brett Kavanaugh也是川普。在后排里边的话这个3位站着的是川普任命的保守派大法官。而在这场听证会里边的话他可能我们可以看得出这个 Clarence Thomas 是属于这个绝对的挺川普的，然后 Sammy Alito 也是一样。但是的话这个John Roberts这部分里边的话，在过去判例里边的话，他是两边都是想办法讨好的。以后但是的话，同样的后面这个关键是川普总统所提名任命的这3位保守派的大法官会不会绝对的支持川普的政策因为川普政府要求是进行狭义的解读，那就是第14修正案的话，它这个提案只是适合黑人的子女，但是的话在另外一个很重要的一个案件里边的话，就叫这个Wong Kim Ark这个Wong Kim Ark 的话，它本身就是一个华人黄金德的案件里边的话他现在这个要解读里边的话是更这个广义的解读，所有在美国出生的子女 都应该成为美国公民。所以的话，我们首先回顾一下子这个案件它的历史是什么，为什么14修正案是怎么解读的以后当时首先这个案件的话是从一个案件叫做Dred Scott 这个案件开始。Dred Scott 的话，他是 Missouri 州在一个黑奴农场里边的话做奴隶的，他逃出来了。后来的话，他要申请要恢复这个美国公民的身份那时候在 Dred Scott 这个案件，最高法院的裁决里边的话，就是黑奴是奴隶主 slave owner 的农场主的财产。所以的话，这个私人财产里边的话你黑奴没有这个权利到法院里边申请，因为的话你本身就不具备美国公民身份。因为这个 Dred Scott 这个案件之后爆发了南北战争，也是美国的国内战争。以后林肯总统的这个是北部的，他是反对黑奴制，南方的军队以后他是来觉得这个保护我自人的私人财产，黑奴也是我的财产，而引发了南北战争。南北战争之后以后林肯总统打赢了以后，南方的这些就要废除这个奴隶制，废除黑奴制。这种情形之下恢复了之后，以后在里边的话有第13修正案、第15修正案、14修正案、第15修正案，这5个这个修正案的话，就是在南北战争之后要废除黑奴制度，所以国会当时的话就是通过了第14修正案。第14修正案里边的话，第一段里边就是争议最大的，法院正在讨论了。这个英文里边的说 ，all person born or naturalized in the United States and subject to the jurisdictions thereof are citizens of the United States and of the state where they reside。那这个中文的解读就是，凡在美国出生和规划以后，并在这个受其管辖者，均为美国公民，还有是居住州的公民。所以现在争议的地方就是集中在中间这句话 subject to the jurisdictions thereof， 谁能够适合。然后所以当时在国会讨论的时候曾经有争议的，因为美国成立不久，它是从英国殖民地里边脱离的，所以在国会辩论里边他有讨论过，好像英国的士兵他在美国本土生了小孩子，这种情况不应该是属于这个美国公民，因为他不效忠美国。当然的话，外交官他们在美国担任外交官，他们的子女不应该属于美国公民。所以当时在国会讨论第14修正案的时候，已经有5大例外的，有哪些人是不属于美国公民的。所以当时狭义的解决，它就是为什么？是因为 Dred Scott 决定了，因为南北战争结束了，国会通过废除黑奴制，第14修正案成为一个很重要的一个废除黑奴制度的一个法规修宪。所以当然的话，这个案件在导致这个被另外一个案件在1898年最高法院来解读。这个解读里边的话，就是这名非常有名的，在移民法，在很多宪法里边的话，我们都要念的，就是这个 Wong Kim Ark， 中文是黄金德。黄金德是何方神圣呢？黄金德他是其实他是在美国出生之后，他应该是1873年在旧金山出生。他父母来美国做这个干苦活修建铁路。出生了之后，但是在1882年，美国通过了排华法案，不允许来自中国的民众申请规划。所以他父母里边的话，虽然是黑奴干苦活来到了旧金山，虽然黄金德在美国出生，但是因为他父母申请不了美国公民，在1895年的时候，黄金德回中国去探亲，但是回来的时候 他被移民局拒绝入境，因为他不是美国公民。所以当然这个案件的话达到了最高法院。究竟黄金德在美国出生，但是父母不是美国公民，他应该不应该拿到美国身份呢？所以当时最高法院的话，在黄金德的案件判决里边，他说他父母是在美国这个他自己在美国出生，所以的话他应该是美国公民，就是因为第14受证案里边讲到的。所以今天我们要讨论的话，就是究竟这个第14受证案应该是按照原文的针对废除黑奴的来解读，或者是按照黄金德的广义的来解读，就是凡是在美国出生，不管你的父母是不是黑奴，你都应该拿到身份，拿到美国公民的身份。当然的话，代表这个川普政府的，这是诉讼总长 John Sawyer， 他是在 Missouri 州出生，以后后来的话到了英国这个牛津大学这个做访问学者，以后后来回到美国，在哈佛大学念法学院。这个是在川普上台的时候担任被提名这个他曾经在川普的多宗案件上诉的最高法院的时候，在2020年的选举之后的话，他是代表川普上诉的最高法院的这个律师，是在最高法院里边呢非常有经验的。他在2025年这个5月份川普提名担任美国的诉讼总长，也是所有美国政府的案件上诉的最高法院都是让 John Sawyer 里边这个担任律师的。代表这个反对方的这个就是 Cecilia Wong 的话是第2代的华裔他在这个 Stanford、Berkeley 毕业，后来的话到了耶鲁大学念法学院是一个民权律师。所以这个 ACLU 是属于美国左派的这个民权团体所以这2个人这个代表来进行。当然的话，这个最高法院他们是不允许拍照只能是录音。我们看看美联社今天的话在开庭的时候这个他们的2方面的争议的地方重点在哪里。在法庭外面的话，还是有很多的这民众来进行游行示威，有反对有支持的，所以这个也是影响非常深远当然在里边的话也谈到很重要一点的话，就是这个美国在来美生子这个产业会不会继续这个存在。因为最高川普的政府在签署总统行政命令的时候对所有的这些在美国出生的子女都不发这个护照现在的话这个最高法院的裁决，现在这个川普政府的律师是要求以往的这个它有2个概念，一个 retroactive 就是追溯以往的案件这个部分他说我们要求并不是追溯以往，就是以前在美国出生的以后他们照常可以拿到美国公民，只是在最高法院判决之后，他们的在美国出生，他们必须要证实父母必须要有一方成为这个美国的个合法居民或者是公民，才能够申请美国公民身份所以这个部分的话是这个所谓的 prospective 将来以后，所以现在川普政府的话并不是要追以往在美国出生的子女是否拥有公民权，他不会从这部分来，而是将来在美国出生是否应该自动拿到美国公民权的。所以这个部分这个大法官里边的话，他们是你可以看得出这个他是在这个右手边的话是贵宾，川普应该是坐在这个右手边的。
We will hear argument this morning in case 25-365, Trump versus Barbara. General Sauer.
Mr. Chief Justice, and may it please the court. The Citizenship Clause was adopted just after the Civil War to grant citizenship to the newly freed slaves and their children, whose allegiance to the United States had been established by generations of domicile here. It did not grant citizenship to the children of temporary
broader national issues.
它现在那个翻译软体的话有一点故障，我看看的话，因为刚才我试的时候它的软体还是可以翻译的，但是现在发现的话，里边的话我再试试看。因为
to the newly freed slaves and their children, whose allegiance to the United States had been established by generations of domicile here.
OK 可以了。
It did not grant citizenship to the children of temporary visitors or illegal aliens who have no such allegiance. This conclusion reflects the original public meaning of the clause. When Congress used the term not subject to any foreign power in the Civil Rights Act of 1866, it rejected the British conception of allegiance. Senator Trumbull explained that subject to the jurisdiction thereof in the clause means not owing allegiance to anybody else. And in 1884, this court recognized that subject to the jurisdiction means owing direct and immediate allegiance. The clause thus does not extend citizenship to the children of temporary visa holders or illegal aliens. Unlike the newly freed slaves, those visitors lack direct and immediate allegiance to the United States. For aliens, lawful domicile is the status that creates the requisite allegiance, and the text of the clause presupposes domicile. For decades following the clause's adoption, commentators recognized that the children of temporary visitors are not citizens, and illegal aliens lack the legal capacity to establish domicile here. Unrestricted birthright citizenship contradicts the practice of the overwhelming majority of modern nations. It demeans the priceless and profound gift of American citizenship. It operates as a powerful pull factor for illegal immigration and rewards illegal aliens who not only violate the immigration laws, but also jump in front of those who follow the rules. It has spawned a sprawling industry of birth tourism as uncounted thousands of foreigners from potentially hostile nations have flocked to give birth in the United States in recent decades, creating a whole generation of American citizens abroad with no meaningful ties to the United States. I welcome the court's questions.
General Sauer, before we get into the broader national issues, would you start with Dred Scott? Dred Scott was a case about state citizenship. It was a diversity case. And of course, we know what Chief Justice Taney did with that. How does the citizenship clause respond specifically to Dred Scott and answers or changes or corrects its answer as to citizenship? The other point is the citizenship clause refers not just to national citizenship, but also to state citizenship. Are we to have two different definitions for those? It's one word, citizens of the United States and citizens of the state wherein they reside. So as you begin, I'd like you to go back at the beginning and be more specific about the answer. And I want you to explain whether or not those two definitions are the same or related, and what state citizenship is based on.
Thank you, Justice Thomas. I'll maybe start by addressing Dred Scott. As you alluded to the fact, Dred Scott, imposed one of the worst injustices in the history of this court, and it led to the outbreak of the Civil War. It's very clear, and this court in all of its early cases interpreting the 14th Amendment said, the one pervading purpose, the main object of the citizenship clause is to overrule Dred Scott and establish the citizenship of the freed slaves. If you look at the debates in the congressional record and discussion surrounding the adoption of the citizenship clause, what you see is a very clear understanding that the newly freed slaves and their children have a relationship of domicile. They do not have a relationship to any foreign power. For example, there's a comment where he says, look, people have been here for 5 generations and clearly have no relationships to any foreign African potentate, or have a relationship of allegiance to the United States. And that reinforces our point that allegiance is what the word jurisdiction means. It doesn't mean regulatory jurisdiction or sort of being merely subject to the laws. They're talking and they're thinking about it in those debates about allegiance. Now, as to your second question, if you look at the text of the clause, we believe it says, born in the United States, born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states of which they reside. So there's a constitutional guarantee that applies to both federal or national and state citizenship. And the key point we make there is that word reside, if you look at, for example, section 1473 of Justice Story's commentaries, was understood to mean domicile. So when they say subject to the jurisdiction, and then they go on to say you're a citizen of the United States and the state in which they reside, the very text of the clause itself presupposes that the citizen is domiciled in the United States. If they're present in a state at all, they reside there. Reside means domicile in the Constitution. And we think that strongly supports our interpretation. It's textual evidence of our domicile-based theory of jurisdiction.
Well, starting with that theory, you obviously put a lot of weight on subject to the jurisdiction thereof. But the examples you give to support that strike me as very quirky. You know, children of ambassadors, children of enemies during a hostile invasion, children on warships. And then you expand it to the whole class of illegal aliens are here in the country. I'm not quite sure how you can get to that big group from such tiny and sort of idiosyncratic examples.
There are those sort of narrow exceptions for ambassador foreign public ships. Tribal Indians is an enormous one that they were very focused on in the debates as well. But what I do is I invite the court to look at the intervening step, which is the enactment of the Civil Rights Act of 1866. And there they didn't say subject to the jurisdiction thereof. There it says not subject to any foreign power. Now, if you go back to Blackstone and Calvin's case, they say it does not matter if you are subject to any foreign power. If you are born in the king's domains, you have this indefeasible duty of allegiance to the king at any time. So there's a clear repudiation in the Civil Rights Act. The Civil Rights Act is this breakwater, which makes it very, very clear that they are not thinking about allegiance in terms of like the British common law. They've adopted the Republican conception of allegiance. So it's from not subject to any foreign power. And then the debates just a couple months later make it very clear that they're recodifying the same conception. They were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof. And one of the strongest statements of this is Senator Trumbull's statement that I quoted at the beginning, where he says, he's asked, what does that mean, subject to the jurisdiction thereof? And he says, it means not owing allegiance to anybody else. That is what it means. And this court picked up on that in Elk against Wilkins when it says, it uses, completely subject to the political jurisdiction, not mere regulatory jurisdiction.
What do you do with Wong Kim Ark's quote of Daniel Webster, who said, independently of a residence, with intention to continue such residence, independently of any domiciliation, independently of the taking of any oath of allegiance or renouncing any former allegiance, it is well known that by the public law, a non-citizen, while he is here in the United States, owes obedience to this country's laws. Now, the examples that Wong Ark Kim used as exceptions are situations in which there was not temporary allegiance to the United States. The children of foreign diplomats whose only allegiance was to their foreign country, and or occupied territory residents, including those citizens in Maine who had been occupied by the British forces. The US had no control over them. And the whole theory of the Indian tribes was similar. The Indian tribes were analogized to foreign diplomats. So what do we do with that?
I'd say two things. First, as the Indian tribes, we think that's a case that strongly supports us because, of course, by 1866 and 1868, there was strong understanding that the Indian tribes were subject to the United States' regulatory jurisdiction.
But not the same way that temporary foreigners were, meaning there was a real debate going on whether the U.S. actually had jurisdiction over Indian tribes. That's why our cases, for the longest time, until that was finally settled, said, absent some act of Congress, our laws don't apply. U.S. laws don't apply to Indians on Indian lands, correct?
I believe you look at the Rogers decision, for example, that we cite in our brief, where they say that they are subject to the
That's later. I'm talking at the time.
Yes, at the time. So as to 1817.
So what do you do during the debates of the 1866 Civil Rights Act and of the 14th Amendment, with the entire discussion of the people who opposed the amendment, who kept saying, we can't pass it because we're making citizens of gypsies who have no allegiance to anybody, and we're going to make citizens of Chinese people who can't be citizens because we're not going to permit them to be citizens. What do we do with those debates and the fact that the proponents of both acts said everyone who's born in the US will be citizens?
First, as that particular exchange, page 2890 of the congressional record from 1866, Senator Cowan gives this virulently racist statement where he says that. And what does he say right at the beginning of that sort of offensive speech? He says, we can't have children of gypsies, children of Chinese immigrants. We can't have them become citizens. And he says, quote, have they any more rights than a sojourner in the United States? So he's trying to persuade the Republicans to his view by appealing to a common understanding that sojourners do not have children who become citizens. So there's powerful evidence there that everybody understood this to, not sweep in the temporary sojourner. And that's why you see for 40, 50 years, you see every commentator who addresses the specific question of temporary presence saying it's not covered by the clause, including for decades after Wong Kim Ark.
General, can I take you back to the Chief Justice's question about the specific exceptions to birthright citizenship that everybody seems to agree were recognized under the common law? And it brings up an important principle about how we interpret the law. When particular problems pop up, lawmakers may enact a general rule. When they do that, is the application of that general rule limited only to the situations that they had in mind when they adopted the general rule? Or do we say they adopted a general rule, they meant for that to apply to later applications that might come up? Justice Scalia had an example that dealt with this situation. He imagined an old theft statute that was enacted well before anybody conceived of a microwave oven. And then afterwards, someone is charged with the crime of stealing a microwave oven. And this fellow says, well, I can't be convicted under this because the microwave oven didn't exist at that time. And he dismissed that. There's a general rule there, and you apply it to future applications. And what we're dealing with here is something that was basically unknown at the time when the 14th Amendment was adopted, which is illegal immigration. So how do we deal with that situation when we have a general rule?
Yeah, I strongly agree with the way that you framed it, that there is a general principle, that's a broad principle that's adopted the phrase subject to the jurisdiction thereof. And we submit that our theory of allegiance and domicile-based allegiance is what explains those specific exceptions that everybody was aware of, but it is broad enough to sweep in future situations. And as you pointed out, illegal immigration did not exist then. Now, the problem of temporary visitors did exist. And it's very interesting that as you look at pages 26 and 28 of our brief, commentators going from 1881 until 1922 are uniformly saying the children of temporary visitors are not included. Now that logic, we say, it naturally extends. It's really an a fortiori case. If you have someone who enters illegally by the 1880s, there are restrictions on immigration. If you've entered illegally, it's kind of a well-established principle of law going back to the Code of Justinian that says you're not allowed to be there. You don't have the legal capacity to create domicile.
But I think, General Sauer, that what you just said suggests that you can't be arguing in the way Justice Alito suggests, because most of your brief is not about illegal aliens. Most of your brief is about people who are just temporarily in the country, where there was quite clearly an experience of, an understanding of, that there were going to be temporary inhabitants. And your whole theory of the case is built on that group. You don't get to talking about undocumented persons until quite later, and at much lesser, I think it's like 10 pages to 3 pages or something like that. So you can't really be going with Justice Alito's theory. You must be saying that there is a principle that developed, that was there at the time of the 14th Amendment. Isn't that right?
We agree there's a principle there at the 14th Amendment. It is the jurisdiction means allegiance, the allegiance of and this is very strongly reflected in 19th century sources, the allegiance of an alien present in another country is determined by domicile. And that goes back to the Venus and the Pizarro. It goes through the Katsa affair in 1853. It comes right up to Fong Yui Ting and Lau Ao Bu that are decided shortly before Wong Kim Ark. So that's the principle. That principle clearly applies here. I also respectfully disagree.
Yeah, and I guess, Mr. General Sauer, where does this principle come from? Allegiance, domicile, allegiance, I think you point to a Lincoln funeral speech as your primary example of where this principle comes from. It's certainly not what we think of when we think of the word jurisdiction, and I appreciate that jurisdiction has many meanings, but the first meaning is like, if you're subject to jurisdiction, you're subject to the authority of. One doesn't say, oh, what that means is a certain kind of allegiance that domiciliaries have and nobody else does. So the text of the clause, I think, does not support you. I think you're sort of looking for some more technical, esoteric meaning. And then the question comes, okay, if the text doesn't support you, if there's a real history of people using it that way, but as far as I can tell, at the time of the 14th, you're using some pretty obscure sources to get to this concept.
Well, I take it straight from the framers' mouths. So, for example, Senator Trumbull was asked, what does jurisdiction mean? He means subject to the jurisdiction. He said, what does that mean? He says it means not owing allegiance to anybody else. He is the principal framer of the Civil Rights Act of 1866. Representative Bigham, who's the framer of the 14th Amendment, is asked, what does it mean in the congressional record at page 1291? He says, within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty. And we've cited many, many examples where the congressional debates reflect that. Then you referred to the oration of George Bancroft. That's one of probably 16 sources, but there's at least 13, counting that one in the 12 treatises we cited, pages 26 to 28 of our brief. There's over a dozen sources that specifically address temporary sojourners. In the 5 decades after the enactment of the amendment, every single one of them says, well, temporary sojourners, their children are not included, including for 2 decades after Wong Kim Ark.
So if domicile's the key linchpin to your argument, and I take it that it is, do we look at how domicile was understood in 1868? Or do we look at it how it's understood today in context of the INA?
The 1868 understanding, I'm not aware of a strong difference between those.
Well, here's where I'm going with it. I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1868. We really didn't have laws like that we do today until maybe 1880. So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says
Well, I'm not sure how much you want to rely on Wong Kim Ark.
but there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in
I know, but
1898,
but that's 1898. Now I'm looking at 1868. You're telling me is when I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
first and second restatements as well, and,
Yeah,
and
but-
decisions of this court.
Yeah, but so it wouldn't be the INA that would control whether you're capable of having domicile. It would be whatever the law was in 1868.
I think that this is addressed by my exchange with Justice Alito from earlier, which is that this concept, jurisdiction, baking in allegiance and domicile is
Congress could
applied to.
continually restrict who may lawfully be present more and more, and you'd say that would be incorporated into it, even though you're telling us to apply the original meaning of 1868.
The original meaning of domicile. And so the question is there any argument that the framers intended to preclude Congress from dictating who can and who cannot establish a lawful domicile here? I don't see any evidence of that in the congressional record, so it's a natural extension.
Whose domicile matters? I mean, it's not the child, obviously. It's the parents you'd have us focus on. And what if, is it the husband? Is it the wife? What if they're unmarried? Whose domicile?
Well, in the executive order, it draws a distinction between mother and the father. That's really the mother's domicile. I think that would matter.
Well,
there.
but 1868 matters, you're telling us. So what's the answer?
The 1868 sources talk about parental. I'm not aware of them drawing a distinction between mother or father, but they say the domicile of the child follows the domicile of the parents.
And how are we going to determine domicile? I mean, would we use contemporary sources on what qualifies as domicile in a state, or do we look in 1868? And do we have to do this for every single person?
And again, I don't see a strong distinction between those because, of course, domicile is a high-level concept, has been pretty consistent over centuries, which is lawful presence with the intent to remain permanently. That domicile, when you come to a new nation, you say, I'm here to stay, become part of their political community, and you become akin to a citizen. And that's reflected very strongly in the case I cited before.
And just to circle back to Justice Kagan's point, it's striking that in none of the debates do we have parents discussed. We have the child's citizenship. And the focus of clauses on the child, not on the parents. And you don't see domicile mentioned in the debates. The absence is striking.
I think the 19th century sources would say a newborn child lacks the capacity to form a domicile, so they're imputed the domicile of their parents. So I don't think they would have seen a distinction between children and parents. I point out that their position, like ours, is forced to look at the domicile of the parents because we look at the exceptions that they accept, like
I'm talking about
tribal Indians and so
I'm
forth.
talking about in the debates over the 14th Amendment and the Civil Rights Act. It's striking that these concepts aren't discussed in them.
I think domicile is discussed. I mean, it's brought up in many.
Allegiance, jurisdiction, complete jurisdiction.
Well, I mean, here's just a few examples. Page 1679 of the congressional record, President Johnson vetoes the first version of the Civil.
我不知道大家有没有办法能够听到声音。刚才有网友说是没办法听到声音，大家看看有没有这个大家能不能听到声音？如果是听不到的话，我再调一下子。然后这个我不想的话，大家听了之后不知道有没有办法能够听到声音？听到 ，OK， 那就好，我可以谢谢。
Rights Act, and he says, I can't sign this because it would extend citizenship to the children of, quote, all domiciled aliens and foreigners, even if not naturalized. And you have all the other sources we cited that say, this is a deeply rooted 19th century understanding. It's reflected in the Venus, it's reflected in the Pizarro in 1814, 1817. It carries through the 19th century, and this court is talking about it in 1892 and 1893 when it's discussing the Chinese Exclusion Acts. Domicile is the key concept that creates allegiance. That's
General, you said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And you can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite. One of the amici, in fact, points like a Mississippi statute, which probably is replicated throughout the South before the Civil War, that says slaves in Mississippi have an indefeasible domicile in Mississippi. In other words, even if they run away, if they get away, Mississippi says, nope, you still live here. right? And so it'd be astonishing, in other words, for the opponents of the 14th Amendment to say, oh, these people are not domiciled and therefore it goes the other way, because actually U.S. law, even if they were brought in illegally and through an illegal slave trade, once they were there, by
Well,
domestic
their
law,
intent is to return as soon as they can, let's say. So they're here, they're resident, and maybe under your theory, which says, well, lawfulness for a different purpose, but they're here, they're resident. Let's take your assumption that they're not here unlawfully. But let's say they don't have an intent to stay. They want to escape and go back the second they can. Are they domiciled?
Under the 19th century law, I think this is the flip side of the hypothetical that we talked about earlier. Under 19th century law, they are treated as domiciled in the United States. So it'd be astonishing. And in the debates in the congressional floor, talk about not this specific case, but to say, look, slaves who have been forced to come here and have been here are lawfully domiciled here. They don't use the way domiciled like they use allegiance. They say they don't have allegiance, that once they've been forced to come here, they don't have allegiance to any foreign or African potentate, and therefore they're—
General, that goes—
How would that apply to the children of illegally trafficked people today? Would the same reasoning apply?
It would turn on whether the parents are lawfully domiciled in the United States.
So if they're brought in illegally, but then they choose to remain and they want to remain and they're domiciled, you would say that their lawful presence is not dictated by whether they were brought here lawfully or not. And that's different from someone who, say, crosses the border unlawfully.
Yeah, I think it would turn on whether their presence is lawful.
General,
in other words, obviously there may be many other important things that could be done to assist people like that. The question is, if they give birth to someone in the United States, that person naturally a citizen, that would turn, based on the original public meaning of the clause, on the lawfulness of their presence. Are they domiciled?
General, can I ask you a question? To follow up on what Justice Gorsuch was exploring with you with respect to domicile, did I understand you to say that domicile is going to be eventually, or is controlled by Congress? Who is domiciled? I'm struggling to figure out who is domiciled in your argument.
The domiciliaries are people who are lawfully present and have an intent to remain permanently. So that's the kind of black letter, understanding of domicile. Now, Congress can't dictate that certain classes of people, legal entrants and so forth, cannot lawfully lack the legal capacity to form a legally binding domicile.
But if that's so, then doesn't it make the domicile for the purpose of the 14th Amendment turn then ultimately on Congress's will in a way that the framers did not intend? My understanding was the framers put this citizenship clause into the Constitution to prevent future Congresses from being able to affect citizenship in this way.
Sure. Very briefly, no, I don't think so, because it is up to the alien whether or not they want to be domiciled here. Now, there may be
collateral consequences. I thought you just said Congress can make determinations as to who counts as being domiciled here.
Yeah,
so if that's true, then it ultimately would impact, in your theory, whether or not this person can claim that they have citizenship for 14th Amendment purposes based on Congress's determination. And I just thought that's what the 14th Amendment was trying to get away from.
Yes, please.
Very briefly, I just point you to the discussion in Professor Warman's amicus brief, where he talks about this is not a new problem. Going back even to the British common law, there's a situation of people who lack a safe conduct and are passing through the king's domains without permission. And he says the best reading of the common law is they are not under the protection of the king and they're not covered by the rule of birthright citizenship.
Thank you, counsel. You mentioned in your briefing and also this morning the problem of birth tourism. Do you have any information about how common that is or how significant a problem it is?
It's a great question. No one knows for sure. There's a March 9th letter from a number of members of Congress to DHS saying, do we have any information about this? The media reports indicate estimates could be over 1 million or 1.5 million from the People's Republic of China alone. The congressional report that we cite in our brief talks about certain hotspots like Russian elites coming to Miami through these birth tourism companies. And here's a fact about it that I think is striking. Media reported as early as 2015 that based on Chinese media reports, there are 500 birth tourism companies in the People's Republic of China whose business is to bring people here to give birth and return to that nation.
Analysis before us?
I think it's, I quote what Justice Scalia said in his Hamdan dissent, where their interpretation has these implications that could not possibly have been approved by the 19th century framers of this amendment. I think that shows that they made a mess, their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out, to where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
It is. And as Justice Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. He said that about statutory interpretation. I think the same principle applies here, and I think we put that in our brief.
Thank you. Justice Thomas, anything further?
Generally, you're getting a lot of questions about immigration, and they harken back, of course, to citizenship, which is defined in or set out in the 14th Amendment. how much of the debates around the 14th Amendment had anything to do with immigration?
I think that the principal focus of those debates has to do really not with immigrants, but with the Indian tribes. I mean, obviously the main goal, the one pervading purpose of this court said in the slaughterhouse cases was to establish the citizenship of the freed slaves and their children. But they were very concerned about the problem of something that they all accepted as a given, which is that the children of tribal Indians are not within the rule of birthright citizenship. So I think that's what they focus, and we draw an analogy to that, to the issue of temporary sojourners. And then, but there are mentions of temporary sojourning multiple places in the congressional debates, and all of those quotes go in our direction.
And there was, Justice Sotomayor brought up Wong Kim Ark. There was no question in that case that about domicile, was there?
I disagree. The court says at the very beginning of its opinion, here are the accepted facts. These are lawfully domiciled here. When it states the question presented, it talks about domicile. When it recites the legal principle at page 693, it says domicile 3 times. And at page 705, at the end of the opinion, it says, here's the single question we've decided. We decided that Chinese immigrants with a permanent domicile and residence here fall within the rule of birthright citizenship.
Justice Alito?
Under the minimum definition of domicile, which I think existed in 1868 and continues to exist today, a person's domicile is the place where he or she intends to make a permanent home. Now, normally you would think that a person who is subject to arrest at any time and removal could not establish a domicile. But we have an unusual situation here because our immigration laws have been ineffectively and in some instances unenthusiastically enforced by federal officials. So there are people who are subject to removal at any time if they are apprehended and they go through the proper procedures. But they have, in their minds, made a permanent home here and have established roots. And that raises a humanitarian problem. And I wonder if you could address that.
If I make one legal and one humanitarian, the legal point is if you look at those cases, for example, Carson against Reed, Park against Barr, this court's decisions in Elkins and Toll against Marino, they talk about the legal capacity to create a domicile, excluding someone who may have the subjective intent, which otherwise would be determinative, as being excluded. On the humanitarian point, I would point out, as I said at the beginning, Justice Alito, that the United States rule of nearly unrestricted birthright citizenship is an outlier among modern nations. It's a very small minority of nations that have that rule. For example, every nation in Europe has a different rule. And the notion that they have a huge humanitarian crisis as a result of not having unrestricted birthright citizenship, I don't think is a strong argument. And I point out, obviously, for reliance-related reasons, this executive order applies only prospectively, and we ask the court to rule only prospectively.
Justice Sotomayor?
I agree with you what the European nation's rule is, but England was always different, wasn't it?
Not until 1983 it changed.
That's not quite true. The Wong Kim Ark does a wonderful job of laying out the English rule. And you claim it was different, but there isn't any treatises or scholars who say it's different. English rule was always by birth. Other countries were not by birth. Let me just go to the implications of what you're asking us to do. You are asking us to overrule Wong Kim Ark. Well, Wong Kim Ark's parents were domiciled in the US, but they owed loyalty to China. They eventually returned to China. So they didn't have a primary allegiance to the United States. So you're not asking that. Are you asking us to overrule then our cases, one of which said that a child of illegal aliens was a citizen? You're asking us to overrule that.
No, first of all, we're not asking you over to rule Wong Kim Ark. We agree with the holding of Wong Kim Ark and much of the reasoning. And then as for those later cases starting in 1966, where the court makes sort of unreasoned references to this
Wait a
issue,
minute, fin top you loose. The respondent unlawfully overstayed her visa and gave birth to a child here. The court, Harlan II, wrote, the child is of course an American citizen. That person wasn't domiciled here lawfully. So you're asking us to overrule that case?
I wouldn't say we're asking to overrule. We think that's similar to a drive-by jurisdictional ruling where there's a simple statement that's not debated. There's no further analysis of it. There's really an assumption there. And we think that's similar to cases where the court just assumes jurisdiction without discussing.
When we ruled in Trind that Indians could not become citizens, the government then after began to unnaturalize many Indians who had been sworn in as citizens. You ask us to concentrate only on the prospective nature of the citizen's order. But the logic of your position, if accepted, is that this president or the next president or a Congress or someone else could decide that it shouldn't be prospective. There would be nothing limiting that, according to your theory.
If, as we asked, the court confines its ruling to prospective relief only, which is
No, I'm saying to you, that's what you're asking us for relief right now. I'm asking whether the logic of your theory would permit what happened after the court's decision in Trin, that the government could move to unnaturalize people who were born here of illegal residents.
No, we believe the court should do what it did in Sessions against Morales-Santana, where there was a ruling that would have deprived people who are already citizens of citizenship, and the court said this applies prospectively only, and we think that's the appropriate course here.
But that's not what we did in Trin.
We think that the Sessions provides the proper course here, and that's what we're asking. We are not asking for any retroactive relief.
Justice Kagan?
General, I think even your brief concedes that the position you're taking now is a revisionist one with respect to a substantial part of our history. And I think that that's in large part because of Wong Kim Ark and the way people have read that case, which of course was in the late 19th century, and have read it ever since then. And what that case suggests is, I mean, there's a very clear rationale. You say, oh, it says the word domicile a bunch of times, which it does. It's a long opinion. It says a lot of things. But the rationale of the case is really quite clear. It says there was this common law tradition. It came from England. We know what it was. Everybody got citizenship by birth, except for a few discrete categories, which were the ones that the Chief Justice mentioned at the beginning. And that tradition carried over to the United States. And then what the 14th Amendment did was accept that tradition and not attempt to place any limitations on it. And so that was the clear rationale, a clear rationale that is diametrically different from your rationale. And everybody took Wong Kim Ark to say that, and to say that as a result of that, of course, birthright citizenship was the rule. And I think everybody has believed that for a long, long time. And I guess my question is this. You have a story about the reasons why we should go back to what you view as the original meaning. And given the long history of this country's understanding about birthright citizenship, what would it take? What do you think it should take to accept that story in terms of the magnitude of the evidence that we would need to see in order to accept this revisionist theory and in order to change what I think people have thought the rule was for more than a century?
Let me make 2 points in response to that, one historical and one legal. Historical point, I disagree with the way you've characterized the understanding of Wong Kim Ark, and I would point to something that's emphasized in their amici's briefs, which is in 1921, Richard Flournoy, who becomes a senior State Department official in the Roosevelt administration and pushes their theory as a temporary sojourners, writes a law review article in 1921 where he says, I think that children of temporary visitors should be citizens. But he admits that is not the understanding of Wong Kim Ark. He admits Wong Kim Ark did not hold that. And he admits that there's an array of authorities that go against him. He talks about careful and reliable, high authorities. And that's referring to the consensus that we point out in pages 26, 28 of our brief. We've got 12 treatises from 1881 to 1922 that all say, including for decades after Wong Kim Ark, that say children of temporary sojourners are not included. What happens between 1921 and the 1930s? Well, Mr. Flournoy became a senior State Department official. He adopted that as the policy of the Roosevelt administration. So their argument is basically saying there wasn't this consensus going back to 1898. The consensus, as their own author admits, goes entirely in the opposite direction. For 50 years, right? For 50 years from the framing of the clause through the 1920s, maybe 60 years, the general understanding when it comes to what the issue here, and was not an issue in Wong Kim Ark, is the children of temporary visitors do not become citizens under the clause. And then the legal point, you referred to the sort of concept of temporary local allegiance, and they rely on the Schooner Exchange, this theory that you've got temporary local allegiance. But if you actually look at page 572 of the congressional record, right at the beginning, introducing the Civil Rights Act, Senator Trumbull says, I said not subject to any foreign power. I wanted to say born in the United States and owing allegiance to the United States, but I was aware that there's a, quote, a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So Senator Trumbull says the reason I haven't adopted the language and meaning that they say should be packed into these provisions is that everybody knows that the children of temporary visitors should not be citizens.
Thank you, General.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wong Kim Ark that followed with respect to temporary sojourners. And I take you've got your well-taken points. But there was, of course, John Marshall Harlan, the great dissenter who dissented in Wong Kim Ark. and later gave a bunch of lectures. And he posed the question about the sojourners. Suppose an English father and mother went down to the hot springs to get rid of the gout. And while there, they have a child, now back in England. Is that child a citizen of the United States, born in the jurisdiction thereof by mere accident of birth? And he says, under Wong Kim Ark, he is. And he continues, I was one of the minority, and of course I was wrong. Now, I'm sure that was tongue in cheek, but now what do you do with that?
I say two things in response to that. First of all, he gave a speech, but we have 12 uncontradicted treatises that say the opposite, that is not what Wong Kim Ark means, and that's not the meaning of the clause. But also, I make a more fundamental point. When you're looking at Wong Kim Ark, one of the dissent has this dominant theme that like you can't be doing this because you can't make and we all agree, or it's obvious that the children of temporary visitors do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides the holding. So the court should be bound by what it says. This is what we're deciding. Again, on page 75, it says this is the single question. Now, there's been a lot of discussion up to that point, but at the very end, they said the single question we've decided is the citizenship status of the children of Chinese immigrants with a permanent residence and domicile in the United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously, they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright citizens.
I understand that's what they say, but your test is the domicile of the parents, and that would be the test you have as applied today, right?
Yes. So if a tribal Indian, for example, gives up allegiance to...
Born today, birthright citizens.
I think so on our test, if they're lawfully domiciled here.
Okay. And then,
I'm not sure, I had to think that through, but that's my reaction.
I'll take the yes, that's all right. And then I just want to ask you quickly about the INA adopted in 1940 and 1952. It uses the same term as the citizenship clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, by the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright. Would there be an argument for reading that statute under its original plain meaning at the time, 1940, 1952, to perhaps have a different meaning than the Constitution?
We don't think that's the best interpretation. I give 2 reasons. One is it would be very surprising if a statute that says exactly the constitutional phrase subject to the jurisdiction thereof were interpreted to mean something totally different or to ossify a then current misunderstanding of the clause. We think that the best analogy here is probably state long-arm statutes. Take a sort of non-controversial example. State long-arm statutes routinely say we're going to exercise personal jurisdiction to the extent of due process. It takes the constitutional standard and it puts it in the statute. And nobody thinks that those ossify, are limited to the precedent, this court's precedents at the time they were enacted. Everyone thinks that phrase due process incorporates, the developing law of due process and minimum contacts and so forth, including from this court. So we think that's the best analogy when you're looking at the constitutional phrase itself and you take it out of a freighted context. The natural interpretation is say this reflects the objective meaning of the Constitution, and the objective meaning of the Constitution is its original public meaning in 1866.
Do you see any notable counterpoints to that argument?
I'm sure there are arguments on the other side. We address them in their brief.
So you're really, at the end of the day, then, this is a straight up constitutional ruling you want from this court, win, lose, or draw.
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling if the court's going to do that on a statutory basis and a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option. That's the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment, subject to the jurisdiction thereof, as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are, on their face, different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point. And this court has held in multiple cases, Heard against Hodge and General Building Contractors, has recognized that they're intended and they did mean the same thing. And that's powerfully reinforced by the congressional debates where you really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed they thought was ambiguous. And so they switched to the affirmative statement as opposed to the negative statement. The affirmative statement is subject to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing. And that is what this court's case law has reflected.
Why didn't they say the same thing?
Again, it appears they prefer the sort of positive formulation subject to the jurisdiction thereof as opposed to not subject to any foreign power. And again, there's a deep concern and lengthy discussion of the potential ambiguity in the Civil Rights Act. They want to eliminate an ambiguity, but do the same thing. And I think that that's very strongly reflected in those debates.
By the time of the 1940 and 1952 congressional actions, where Congress repeats subject to the jurisdiction thereof, given Wong Kim Ark, one might have expected Congress to use a different phrase if it wanted to try to disagree with Wong Kim Ark on what the scope of birthright citizenship or the scope of citizenship should be. And yet Congress repeats that same language knowing what the interpretation had been. So how are we to think about that? I
think baked into that question is an understanding, I think that was reflected in Justice Kagan's earlier question, that everybody understood that Wong Kim Ark meant that, and the history I talked about, I think refutes that. That really there's a consensus that goes our way for decades and decades after the adoption of the amendment and after Wong Kim Ark on the specific question of the children of temporary visitors. And it's really not until, and again, their author in 1921 is saying, hey, the other side is a consensus.
I'm sorry.
Sorry, go ahead.
But there's executive branch interpretations and others. And if you're in Congress in 1940 and 1952 and you want to limit the scope of Wong Kim Ark or to eliminate ambiguity, why do you repeat the same language rather than choosing something different? For example, you could use the language from the Civil Rights Act of 1866 or some similar formulation if your idea in 1940 and 1952 was to not have ambiguity or not have an overly broad scope.
I think if you look at the structure of that statute where it's 1401A and then B through H, A, and it says these are the people who are entitled to birthright citizenship. A is the constitutional standard, and then B through H are all the categories that Congress has superadded to that. I think the natural inference is that Congress is codifying, which it was consciously doing in 1941, pulling all the naturalization rules and immigration rules together into one statute and said, you go to one place, here's who is a birthright citizen. A, those who are guaranteed that right by the citizenship clause, and B through H are the ones that Congress has added through its naturalization power. So that inference to me says, A is merely, it's not trying to change or alter the constitutional standard, just saying, hey, the baseline is what the Constitution says, and we codify that, and then we move on to the new categories.
Of what relevance, if any, do you think Section 5 of the 14th Amendment has here that gives Congress the power to enforce the article, the 14th Amendment, by appropriate legislation? Does that give Congress room here, or do you not think so?
I do think that a ruling in our favor would leave room for Congress. I don't think you'd have to rely on Section 5. I think that Congress has its own inherent power to grant citizenship by statute. So if the court were to rule in our favor for the classes of individuals that they say should be covered, Congress has the latitude to do that.
How much room do you think Section 5 gives, if any, and it may not be any, Congress to interpret the phrase subject to the jurisdiction thereof or to define that? Is that relevant at all?
It's a great question, and I'm thinking about it for the first time. I assume it would be governed by the congruence and proportionality test from this court's case law. How that would apply here, I don't know. And I don't think it's presented because our contention is that the statute means exactly the same thing. If anything is congruent and proportional, it's not. And I think the court held that in the United States against Georgia.
You've mentioned several times the practices of other countries, and that's obviously, as a policy matter, supports what you're arguing here. But obviously, we try to interpret American law with American precedent based on American history. That's certainly what I try to do, and I think you try to do. And so why should we be thinking about, even though as a policy matter, I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this. Doesn't that, I guess I'm not seeing the relevance as a legal constitutional interpretive matter necessarily, although I understand it's a very good point as a policy matter.
Yeah, I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side in there, amici say, make it a prediction, end of the world type predictions, and our point is, it's a very small minority of countries. Almost every country, and certainly all European countries, have a different rule, and the world hasn't ended there.
The other side, last one, the other side relies heavily, of course, on Wong Kim Ark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wong Kim Ark that the holding is relates to domiciled aliens. And so we strongly agree with the holding. We think domicile was the touchstone. And we think that's not a coincidence for the reason I maybe speculate a little bit when I was talking to Justice Gorsuch about how the dissent raises this. And then the majority's like, we're putting domicile in there, so we know that the absurd conclusion that they say would come from this isn't there. But also domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's deeply rooted in their understanding when they're doing it. They talk about domicile in Yickwo against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding again that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wong Kim Ark that we discussed. We think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wong Kim Ark.
Thank you.
Justice Barrett?
So General Sauer, I want to zoom out a little bit and think about jus soli and jus sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches. Jus soli, the English common law, roughly following the soil, jus sanguinis, roughly citizenship following the parents. Now, jus soli was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who were citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel, it would have made sense in some ways for them to say, okay, we're going to follow, if they wanted to accomplish what you're saying they wanted to accomplish, you could say, well, we're going to follow jus sanguinis because we're going to make it all ride on parentage. But instead, I mean, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the jus soli kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as to soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional jus soli rule and a narrower view of the jus sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
I think you do. And I would say, I think the right way to conceptualize it, it is a modified jus soli. Because even the British sources don't just say you're born here, you're a citizen. They say you're born here and you have to be under the protection of the sovereign. You have to have a relationship of allegiance. Allegiance is the word in Calvin's case.
But they don't focus on the parents. It's the child. And your approach focuses on the parents' allegiance.
Yeah, I'm not sure that that's true.
It seems a little ambiguous, and I'm going to ask your friend on the other side of that question.
Let me point out then that there are two criteria. One is birth on the soil, and the other is allegiance or allegiance. What we have is birth on the soil remains the same, right? And so they are, and that's why so much of Wong Kim Ark is actually we agree with, because they are adopting a modified British rule. They are not going the French rule, that Vattel talks about, where it's like who's the citizen. That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates. But they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. I mean, going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes for late 1700s reflect that. And again, you look at the 1868 congressional report that we cite there, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of allegiance was not accepted. So they accept birth on U.S. soil, but then they take the concept of allegiance and give it its Republican, democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, and let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called?
好了，大概目前的话，我们总结一下子这几位法官的提问，以后我们往往从提问里边的话，可以看出他们的立场是什么。在这里边的话，我们可以看一下子的话，一个很重要一个 concept 究竟是川普总统他现在要推动的话是加以来解释第14修正案，以后这个修正案究竟是这个怎么样解读？以后当然这个保守派的大法官这个就是我们的Clarence Thomas 他就从这边来暗中帮忙这个 General这个Solicitor General， 他的翻译是错的，是不是将军 ？Solicitor General 的话，他是这个所谓的这个听证会里边的话，他是他是所谓的总诉讼长所以这个部分里边的话，它里边提到的一个很重要的观念，就是这个应该不应该遵守这个以前的判例当然在目前你可以看得出这个诉讼长是非常聪明的。他说1898年的黄金德的案件判决里边的话，他的解读第14修正案的解读应该就是这个确定了他们的这个很重要一点，他是不是居民。而从居民里边的话，他在引发你怎么知道他是不是居民，不是说你居住这边就是有居民，而是说你有没有效忠美国。所以话这个部分他引用了很多当时在第14修正案在制定过程之中，他们举出了很多例子英国的军人在这边以后，他们的小孩子以后在美国出生，是不是因为真的自动成为美国公民呢？不应该，因为他们是效忠英国，不是效忠美国。所以的话，他的概念的话，就是在制定14修正案的时候，他们已经考虑到这个居民呢，虽然国会当时制定法规的时候并没有确定是什么情况之下作为居民。第二种的话，在这个他引发这个观念的话，他说居民从当时立法的这边争议的地方呢，就是是否对美国这个新的国家的一个效忠。如果是效忠的话，那基本上你就应该成为一个居民。不单止，当然的话Clarence Thomas 再度引发，他说这个14修正案里面就是黑奴不单只是这个美国的公民，如果是他是在美国居住的话，他们是应该还是这个州的居民，所以是狭义的解释。当然这个部分里边的话也可以看得出Sammy Alito 这位保守派的大法官的话就是他引用了以前的一个判例，就是 Scalia 做主审大法官的时候，他里边提到的就是微波炉原理。他说在以往这个我们最高法院在判决的时候这个假如是偷盗罪是财产的部分，以后你现在的话真的时候偷微波炉那时候并不知道有微波炉的出现，你现在的话在80年代有了微波炉，所以的话我们不能够说偷微波炉不算偷，因为那时候在18世纪19世纪并没有微波炉。他就是说在18世纪19世纪的时候，尤其是在国会制定14修正案的时候，我们并没有非法移民的问题。以后相反的，那时候美国叫扩充，因为你只要搬到美国来，你都可以圈地。所以这种情形呢，它是现在不一样的。所以现在随着时代的变化，我们最高法院也应该要随着时代的变化。所以从这两个大法官的引导或者是询问里边，我们可以看得出，他们是认为以后时代的变化。尽管14世纪这个第14修正案当时是为了黑奴，后来的话在1898年黄金德的案件的时候的话这个还是这个在美国出生还是可以成为公民这个部分的话，因为那时候的这个时代需要这个移民，然后当然的话现在时代已经不一样了，所以从这两个的问答里边的话可以看得出他们是比较倾向支持川普的这个政策的。但是从另外3个法官保守派的法官问的问题，尤其是 Brett Kavanaugh 的问题的话，他里提到2个重要一点的东西。他说在国会在19世纪制定民权法案的时候，也就是这个并且在1952年国会要通过的这个移民法的时候，那时候如果是真的要限制美国这个公民的身份的话，国会那时候的立法就应该通过，为什么不提出来呢？那这个部分里边呢，就是说如果是真的是这个不适合黄金德的案件的话，你国会可以透过修法的 原因来进行解释。以后有2次机会，你们都可以的，国会通过来解释。可以的话这个只有美国出生的人这个父母是合法身份的人才能够获取到公民身份。从另外一个的话，他说你举例说现在遇到很多的问题，欧洲那边说欧洲的所有国家都要证实父母一方是合法或者是公民才是子女才能够公民。所以针对这个部分里边呢，Brett Kavanaugh 他的立场就是说，这个是现代的边呢，这是 public policy。我们 public policy 的话，公共政策的话是国会透过立法的，我们法院是要遵守以前的判例。那当然这个我们看到的话Amy Barrett 他的问题里边就强调，他说你现在强调来 argue 去，就是父母的身份他们是不是美国合法的身份。但是我的解读应该是，你怎么解释的话，这个是不是适合于子女呢？是不是考虑到这个从黄金德的案件到这个第14受证案它制定的时候，应该考虑的是子女是不是有这个意图来留在美国呢？那当然这2个解读的话，这2个法官还有包括 Gorsuch 这部分的话，他们表态里边呢，可以看得出他们是有一点感觉到的话，这个不一定是能够符合会支持他这个川普的政策的部分。当然这个部分你可以看得出，从盘问里边这个可以看得出他们有一定的倾向了。那当然这个我们看到的话，只是他们现在首先进行了一部分的这些提问待会的话我们会看到这个反方律师这个 ACLU 的律师这方面的一些他们的说法。从目前看起来的话这6位保守派的法官很明显的话两名是支持川普狭义来解读14受证案的。但是从保守派法官的问题里边的话，也可以看得出他们还是没办法来确定一定会帮川普的忙。当然的话这个另外2-3位自由派的法官基本上的话，他们强调一点的话，就是黄金德的案件是最终的判决，我们必须要遵守所谓的 stare decisis， 就是遵循前例，因为我们沿用的是英国的这种 common law 普通法的解读的话，就是这个不能够随便这个抛示前例。所以从目前看起来的话个立场已经有一点出现是 Sammy Alito 跟 Clarence Thomas 是坚持川普的狭义解读以后3位自由派的大法官问的问题是要坚守黄金德的判例。那当然下面这部分的话，我们再来听听这个反方的律师他们的说法。
part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because I'm mindful of the time. What do you do with Wong Kim Ark's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on.
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take a further step at that point and say, therefore, if you have temporary local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding, where it says
you
domicile,
say Wong Kim Ark incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say perspective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get it.
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which really happened in a tiny minority of cases,
After the
is
fact.
directly addressing that guidance.
After the fact,
Yes.
after their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I mean, I'm summarizing because I'm not an expert in
Yes.
computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that there's the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, counsel. Ms. Wong?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on US soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession, because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, the fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other US-born persons.
We've heard a lot of talk about Wong Kim Ark, and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, and including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion, that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means, again, looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance. And those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too. But then what are those 20 domicile words doing there? Like you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case. And he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion, but in Wong Kim Ark, it's a long opinion, but it begins by saying, here's the question, and it ends by coming back to the question. And it says, here's the question stated at the beginning of the opinion, namely whether a child born in the United States or parents of Chinese descent who at the time of his birth are subjects of the Emperor of China but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exception, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile in there? It's just something, it's something irrelevant that he wanted to throw in. It's like, whether a child born in the United States of parents of Chinese descent who once resided at a particular address in San Francisco who attempted to enter the country at the port of San Francisco? Why put it in if it's irrelevant?
Well, Justice Alito, I'll give you two responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule, you get to the same result for people without domicile. Wong Kim Ark says 6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well,
that
Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities took the view that the non-domiciliary question wasn't decided, remained open, and even continued to press the view that domicile is required? Now, I know you've got a lot of good stuff on your side too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in DC. So here's what I would say. All of the government citations in their brief generally either were rejected by Wong Kim Ark expressly if they predated Wong Kim Ark.
If we're trying to understand how the legal community understood what happened in Wong Kim Ark,
Sure.
it seems to me it's a mess.
So
maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side post-Wong Kim Ark is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again, discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark and temporary sojourners' children are US citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again, citing Lynch, or Kent, and stating the rule that everyone born in the US is a citizen, and saying, look, children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children born in the United States are citizens. We have an 1896, so a couple years before Wong Kim Ark, but an 1896 State Department regulation, which said the US born children of foreign nationals are US citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a US attorney who writes in a law review article that he's talking specifically about temporary sojourners' children. And he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
Ms. Wang, can I,
Yes.
can I offer a possible explanation for why Justice Gray made a point of putting domicile in what he said was the holding of the case? And it is this. Wong Kim Ark and his parents, had they come to the United States from Europe, could have been naturalized. But because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part of the American society. At the same time, there were many, many men who were horribly exploited, brought to the United States to work on the Transcontinental Railroad, to work in mines. They were worked to death. They were treated horrifically, but they were not They were overwhelmingly men. There wasn't an indication that they would stay here, they could stay here, they didn't have permanent homes. And the opinion is drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why domicile is mentioned in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule. That explanation would be inconsistent.
But Ms. Wong,
yes.
Isn't that explanation, I take Justice Alito's point, and I think he actually makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not a part of the rule, meaning he wasn't saying you had to be like a foreigner who is doing everything they can and who can't be naturalized, but he might have emphasized those facts in this case precisely because Chinese immigrants were unwanted, precisely because he had to get this out into the public and people were going to say, whoa, you're saying these people have to, this baby has to be a citizen? And so one could imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular people in this case were in Justice Alito's first category.
I think that is very possible, Justice Jackson. And as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government.
Absolutely, that at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, you know, who knows why the majority opinion mentioned domicile. We know is a stipulated fact. We know the government tried to renege on that stipulation and rely on this assumption on the part of anti-Chinese advocates at that time that Chinese people couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. White, can I move? Oh,
Go ahead.
I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions, so I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule. And this is what I mean. And this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereigns, separate nations in the American system. If you look at occupied alien territory as territory that's outside the jurisdiction of the United States. And then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country. And even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Quirin, or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is this sense that the person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, ex parte Quirin, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of US territory. So,
And that's, just to interrupt for 1 second to
Sure.
clarify, and that is territorial. Sometimes it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception. I don't think that is the best way to think about it. Rice and English tell you that when the British forces are occupying Castine, Maine, no one is subject to US jurisdiction there because Britain is governing Castine, Maine. And Justice Story explains, look, if the US then retakes that territory, babies who are born to US citizens by what he calls post limine become US citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were US citizens. And Professor Muller goes on to explain that there are many cases of those US citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are US citizens like everyone else. So again, the touchstone for enemy aliens is
So
is
what
there an
about
occupation?
Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just in
Sure.
the entrance of time, just to
Sorry.
focus you, how I understand why the Indians are treated differently for purposes of the law, but I want to know, is it tied to territory or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as the tribal member is like an ambassador, or you can look at it like there's a territoriality issue where people are born on tribal lands, and therefore they're essentially, I think he says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot in Elk, and some of it's not terribly helpful for you, it seems to me, because Justice Gray, again, strikes again, says that they may be subject in some degree of respect to the United States. So there's some jurisdiction. He says they're born in the geographic limits. They are in a geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part of Elk versus Wilkins' holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. The government tries to make it seem as though what sets the exceptions apart, what defines the exceptions, is that the government has some maximum theoretical power. The government could have exercised plenary regulatory power over the tribes, and therefore that's the same situation as a foreign national in the United States. But that's actually not true, because remember, if there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them, excluding from apportionment, which was renewed in the 14th Amendment. And that's not true of foreign nationals. If the government were right, that the question is what's the maximum theoretical power the government has, there'd be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comedy considerations there. That's how you define the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wong, on the earlier answer you gave to Justice Gorsuch on the temporary sojourners cases, those were distinct cases, correct, where the parents had come to the U.S. and didn't want to give citizenship to their kids, took them out immediately, correct?
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress obviously framing both. Congress was trying to do the same thing with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if the citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the 1866 Civil Rights Act was reenacted after the adoption of the 14th Amendment and remained in place until 1940.
Sure, the framers were trying to do the same thing with the language in both.
Okay, so then I think we can turn to the language of the 1866 Civil Rights Act because it's more straightforward. You know, subject to the jurisdiction thereof is like the, the puzzle wrapped in an enigma, wrapped in a mystery, but not subject to any foreign power is pretty straightforward. So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government. Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who are nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service. It sure seems like that makes them subject to a foreign power.
But again, Justice Alito, that would have meant that the children of Irish, Italian, and other immigrants, which Wong Kim Ark refers to and the debate the framers refer to, would not have been citizens either. Because if the only test is whether that US-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be
in all of those cases, the parents could be naturalized, and then the children would be derivatively naturalized when the parents were naturalized. Wong Kim Ark, I'm sorry, the red light is on. Wong Kim Ark has a passage explaining how this court should treat dicta. And it quotes something that John Marshall said. It is well, this is quoting from Wong Kim Ark, it is well to bear in mind the oft-quoted words of Chief Justice Marshall, it is a maxim not to be disregarded, that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for a decision. So does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, Counsel. Justice Thomas? Anything further, Justice Alito?
Well, just a couple more questions. So if those who framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede
对不起，现在呢才知道的话没有声音，所以这个部分的话，这个不好意思，因为当然的话，这个解读基本上重复一下子的话，可以看得出现在这两党的争议的话也是非常激烈的我刚才提到的话，就是重复一下子的话，就是因为现在这个国会没有办法通过修宪的方法来解读两党争议的部分。现在你可以看得出就是旅游生育能不能继续进行，但是在最重要一点的话是我们这个在立法没办法通过，那对黄金德的案件怎么解读？然后最高法院的几位保守派的法官，他应该觉得的话这个黄金德的案件就解读，就是黄金德之所以能够成为美国公民，因为他的父母是 domicile 是在美国居住的。虽然因为这个排华法案他们父母不能够归化，但是的话他们在美国生活，所以的话他们已经属于美国的居民，他们的子女应该是得到得到公民身份。所以从这个部分的话也是一样这个保守派的法官假意来解读黄金德，因为在黄金德的案件你可以看得出辩方的这个反方的律师这个Cecilia王他强调的话最重要是两个最重要的原因他说要这个认为川普的行政命令不能够生效。第一个是黄金德的案件，这个我们必须要遵守普通法。在世界上里面有两个法律的体系，一个所谓的普通法 common law， 一个是大陆法。大陆法的话就是不需要遵循这个以前的判罚，但是因为我们美国采用的话是 common law， 是英国的common law， 遵守以前的判决，所以的话他是这个反对方的律师他强调的话这是反对方。另外一个的话就是他强调的一个最重要另外一个因素这个要维持原判的话，就是说你看看如果是最高法院推翻了这个黄金德的判例，那我们美国会大乱，有很多这些在美国出生的以后他们现在面临他们的身份已经被剥夺，但是这个是混淆是非的。在听证会里边这个并且在文件里边，川普的政府的律师已经一再强调，他现在要求最高法院对这个出生子女的公民权的判决不是追溯以前，而是在判决之后在美国出生的子女不能自动成为美国公民。所以这一点里边的话，很多大法官已经对这个 ACLU 反方的律师有觉得困扰是非，因为在所有的因为最高法院2个小时的辩论不是说让你从头开始来，其实双方都已经递交了所有的这个文件，始至终川普政府的律师一再强调的话就是说我们是 perspective 的话就是在判决之后，而不是说现在辩方的话他是反方律师他说如果是这个之后的话会追溯到以前拿到公民的在美国出生父母没有身份的这人士，所以这个是完全困扰是非的。所以这个部分我相信的话这些大法官已经知道反方律师他已经很 desperate， 也很 desperate 的话就是这个困扰是非的做法，因为在里边一再强调的话是将来会，而不是在追溯以往的这个案子。当然的话还有一点这个因为辩方律师强调的就是黄金德的案件，在黄金德的案件里边和再度的解读里边的话这个你可以看得出基本上完全是完全是这个就是坚持黄金德，但是的话在Sammy Alito's 他反而变成川普政府的律师一样的盘问。如果是这个1866年的民权法案里边的话对 domicile 并没有做出很明确的，但是的话在所有的这些这个判例项看起来里边的话这个国会给印第安的印第安人有例外，他们是这个对 敌国的这个军队在美国出生的也有例外，不能够成为美国公民对外交官的小孩子不能成为美国公民，所以列举了一下子以后 ，Amy Barrett 这位刚开始对川普律师不友善的这个保守派的法官，反而的话就是说，那有那么多的例外的东西，那你这个反对方他怎么样解读的这个部分呢？所以的话，这个将来就是大家也是在重新解读黄金德的案件所以刚才的话这个刚才的话这个部分所以我现在的话这个现在有声音，谢谢大家的提醒。所以的话当然最后有的时候你听了之后Sammy Alito、Clarence Thomas 的目的是这个立场是非常鲜明的。第14州政案基本上是维护这个解读这黑奴的子女应该成为美国公民。然后这个当然自由派的法官基本上是跟反方的律师站在一起。黄金德的案件就是判罚凡是在美国出生的子女必须要成为美国公民。然后当然反方的律师最致命一点的话，在法院在大法官面前，在法院面前你不能够 misrepresenting the facts， 不能够歪曲事实。那个事实里边的话，就是川普政府的律师并没有要求追溯以往的身份，而是在这个最高法院里边的话，他居然睁着眼睛说瞎话。他说这个会造成大乱，很多以前拿到美国公民身份的人士以后他们的身份会丢掉。但是的话，在法院的文件，在所有的川普政府所追溯的提出的政策里边的话，是在最高法院判罚之后，你不能够这个你必须要证实你的父母是在美国，是 domicile， 是在美国，是居民，是效忠美国的。所以这个解读里边的话，对反对方律师是非常致命的。你睁着眼睛说瞎话 misrepresenting the facts 的话，对法官的可信度是很严重的那当然3位自由派的法官可以看得出来他们基本上都说按照遵循原例这个先例，因为以前的黄金德的案子判罚都是属于这个不能够这个所有在美国出生的子女。但是呢，现在保守派的大法官Alito 的解读的话，他说不对，就是最高法院当时裁决的话，因为他父母虽然不是规划的，因为排华法案的话不能成为美国公民，但是的话，因为他们是 domicile 在美国以后，并且他们已经可以这个他们是应该是子女应该是合法的成为美国公民。所以这个解读里面的话，而另外这个4位这个保守派的法官立场包括 John Roberts 他们的意图的话提出了几个意图。这个意图里边的话就说但是最重要一点的话他们强调的话问的问题是可以说做两方的解读Amy Barrett 的话John Roberts 还有 Kevin 这个 Neil Gorsuch 还有这个 Brett Kavanaugh 这4位保守派的法官的问题，它集中在2方面。一方面的话，在1866年已经通过的民权法案，为什么那时候不具体的解说呢？就是为什么要这个国会已经有这个机会来确定的名单，但是没有确定这个哪种人可以呢？所以这个部分是两面剑，有的时候解读是国会故意留下来，然后后来的话这个透过黄金德的案件做了更明确的一刀切的这个决定。当然另外一个的话就是这个国会这个完全可以透过立法的手段，但是从目前的政治形势的话，川普没有办法能够在众议院能够拿下众议院的票，但是拿不下参议院的票。以后参议院里边这些共和党的人士只有这个53票，而要停止 filibuster， 要终止这个要拿到60票才能够进行公开的投票。所以针对这个部分，当然这个川普有没有别的方法？如果是万一最高法院对他这个否决了他这个公民权的行政命令，那有可能他会推动国会的立法。那这个立法的程序之下里边的话，现在这个 DHS 的经费还有拯救美国法案， 还有这个有可能会这个取消公民身份，规定哪种人可以。从目前看起来的话，所有的大法官可以有一点共同点的话，他们都认为有可能国会有这个权利来修正第14修正案，规定哪些人可以拿到美国公民，哪些人不能够成为公民。他们这个透过立法的程序的话，就是非法移民或者是这个父母必须要双方有一位是合法居民或者公民人士才能够拿到公民身份，所以有可能会透过立法。所以如果是这种情形，川普政府有可能，川普总统的话会全力推动，要求改变filibuster 这个规定。filibuster 的话就是要60票才能够终止辩论这个部分。所以现在目前呢有3个案件，川普正在这个期望呢这个国会参议院改变游戏规则。他在昨天的记者会里面强调，如果这个民主党当权了，这掌控了参议院，这个他们一定会改变游戏规则，将60票变成51票。这个不是这个是肯定是会做，只是第一个小时或者第一天才去做。所以他呼吁的话，这共和党有可能要改变游戏规则，然后将这个60票变成51票，就终止这方面的讨论。所以这个部分有可能川普总统会采用这种政策，通过国会立法来限制公民的这个公民权。好的，因为这个谢谢大家的参与，就刚好有10分钟的时间里边的话没有声音，所以现在已经调好了，所以我就补充这种说法。谢谢大家的参与，我们下集再会。